You may have heard talk of a humanitarian and compassionate application, an H&C application inside Canada, and are uncertain as to whether or not this may be applicable when applying for work permits, study permits, or if it applies only when applying for permanent residency. What exactly is an H&C application? Well, an H&C application is an application for permanent residency available to persons who may not otherwise be eligible to apply for Canadian permanent residency under the other options. Welcome back. My name is Donovan Francis. I'm a Canadian immigration lawyer at Goose Law Immigration, where we help companies with their employees to submit their Canadian visa application without the legal hassle. In this video, I want to talk to you about H&C applications, humanitarian and compassionate applications. These are applications for permanent residency inside Canada. H&C applications do not apply for temporary residency applications such as work permits or study permits or visas. These applications are only for permanent residency applicants. Now, that does not mean that somebody who's applying for a work permit and who has certain humanitarian type grounds may not include those arguments in their work permit application. But that is not in and of itself an H&C application. That would just be a work permit application that includes some arguments that are humanitarian and compassionate based. But generally speaking, where one is not able to apply for permanent residency under the regular programs, that person may be able to apply for permanent residency under the H&C option. And this means that they would be appealing to the heart and mind of the Canadian immigration officer by arguing that their lives have been impacted by certain set legal grounds, established legal grounds, and by virtue of that, their application for permanent residency should be approved, notwithstanding the fact that they are unable to apply under the regular PR options. All right? Now, an H&C application, first and foremost, is a discretionary application, meaning that the immigration officer reviewing these applications has the power to decide purely based on their discretion, right? They have the discretionary power to decide on the application. So that's important and something to bear in mind. Secondly, H&C applications only work if they fit within the stipulated grounds. Now, there are certain grounds on which an H&C application can be based. One of those is on what's called establishment in Canada. So if someone, if you've been in Canada for an extended period of time, typically for 2 or more years, the longer you're here, then the stronger your claims on establishment grounds are going to be. But if you've been here for, a period of time of 2 or more years, and you've become established in Canada. Maybe you studied in Canada, maybe you've worked lawfully in Canada, maybe you've established a home in Canada, whether it be that you've leased somewhere or you've bought property. You have bank accounts, you're involved in the community, you go to the mosque, you go to church, you engage in a volunteer role, you're involved, your kids are active, if you have kids and so on, then you are going to be able to make the argument that you've become established in Canada and that it would be unreasonable to uproot you from Canada and force you to return to your home country. So making an argument on the establishment ground is going to be important in an H&C type application. Another very important ground, if applicable, is what's called the best interest of the child grounds. And this is where you, the applicant, you have a child with you that has been with you in Canada and who has also become established in Canada. And if that child were to be removed from Canada, then it would have a significant impact on the child, physically, psychologically, socially, financially and otherwise. If that child is a Canadian citizen, if that child were born here, then it makes for an even stronger argument, arguing that it would be not in the best interest of this child to be removed from their country of citizenship to another country. But the best interest of the child argument also applies where the children are non-citizens, right? So if there are children involved, then this is also going to be a significant grounds on which an H&C application can be based, right? And it's not one or the other. So it can be a combination of establishment, best interest of the child, another grounds could be family ties inside Canada. And that could be somewhat related to the best interest of the child argument if you have a child whose family, if you have a child who is a citizen with you here in Canada, or if you have other family members inside Canada, cousins, aunts, siblings, you have other Canadian family members who are here, then it means that you'd have had significant ties to Canada, and therefore you'd have had stronger grounds on which to make a claim for permanent residency on H&C grounds. Another factor that is taken into consideration but is not as significant a grounds as the others is what is likely to happen should you have to leave Canada and return to your country of origin. Are you likely going to be facing undue hardships? Are your kids likely to face undue hardships, and so on? So that's another factor that is going to be taken into consideration when doing an H&C type application for permanent residency. So those are some of the considerations that we advise our clients to bear in mind when they're applying for H&C, for permanent residency on H&C grounds. And it's going to be important that your arguments are credible arguments, and so it's going to be important that you provide supporting documentation. And so we push our clients to provide us with documents that support all of the claims they've made on each ground. For instance, if they're arguing that they've become established in the community, then we want to see letters of support from members of the community, Canadians, Canadian citizens and permanent residents who have had interactions with these foreign nationals and who can attest to the value that they're going to be bringing to Canada. Some kind of letters of support from current and or previous employers in Canada talking about their contributions to Canada. If there were students, transcripts and letters of support from teachers and so on. The kids talk about the things they're doing in their school, see what their teachers are saying. All of these things are going to be important because remember that an H&C application is a discretionary application. And so you want to be very convincing in your submissions, but your submissions, very important, must be credible, okay? Your claims must be credible. And ultimately, it's important to always remember that this is a discretionary type application. There are no guarantees. Well, there's never a guarantee that any application is going to be approved. But with these discretionary type applications, there's even a greater chance that an officer might not be persuaded by the arguments that would have been included in the application. But at the end of the day, it is an option, and it typically is referred to as the option of last resort. And again, it's available where one is not otherwise eligible to apply for permanent residency under the other options that the government would have created. All right, so I trust you found value from this. As always, remember to like our videos so that others will see more videos like this. Subscribe to our channel so that you're notified the next time we publish a video, and check us out on go.gooselaw.com. Thanks, see you again.